corporate and commercial is divided into two parts. We have what we call corporate transactions and commercial transactions. I made it clear that first term and second term, you deal with commercial transactions. These are transactions that include money. So the first one you looked at was sale of goods and procurement. So now we are looking at another one of the oldest and basic, okay, transactions known as employment. Okay? Employment. Everyone wants to be an employer. No one wants to be an employee. But the circumstances always send us to that. Okay? So now, first and foremost, when you are dealing with employment, first understand what laws govern employment. Okay? The first law that governs employment is the Constitution. Okay? The first law that governs employment is the Constitution. So if it is the Constitution, ask yourself, because we are going to read all these laws I'm telling you. Okay? The first one is the Constitution. After the Constitution, you have the Employment Act. Okay? After the Employment Act, you have the Contracts Act. Okay? After the Contracts Act, you have the Workers' Compensations Act. After the Workers' Compensations Act, we have the Health and Safety Act. Okay? Remember, all persons have a right to employment. But under these persons we are looking at, we have persons with disabilities. So that will take us to persons with disabilities, regulations, and also among the persons we are employing, we have children. So we shall look at the Children's Act as well as the employment of children's regulations. Okay? Then, due to the fact that the reason why we work is to save, saving is divided into different categories. We have what we call mandatory deductions and optional deductions. So as a result of that, the mandatory deductions include NSSF. So we shall look at the NSSF Act. So briefly, list, those are the laws you should have appreciated by the end of today. Okay? So, when we are dealing with employment, we are going to answer the following questions. 1. What is employment? What is employment? Then 2. Who can be employed? Who can be employed? Who can be employed? Then 3. How do we enter into a contract of employment? How do we enter into a contract of employment? Then, what are the duties, rights of the parties, the contract of employment? What are the rights and duties of parties, the contract of employment? The contract of employment. Then, what remedies are available in circumstances of breach of the said duties and obligations? Before we leave this place, We should have exhausted everything. Inshallah. The last one is what remedies are available in circumstances of breach. Okay. Okay. So we are going to be answering those questions, but in reading the law. So we are going to be reading the law when we are answering those questions. And by the time we get done, it's going to be a walkover, like eating yellow bananas. Okay, you just swallow. So anyone with a compendium of employment, okay, someone with a constitution as well. So I want to read. Okay, I'll read. Okay, someone with a compendium. We get ready. Let's all get our laws. Okay. Then after, someone in the Constitution read for us Article 40. Okay. We are going to first read those laws. Okay. Then by the end of those laws, you will see that you have answered all those questions. Okay.
Excuse me, Counsel.
Yes.
Sorry, my network checked me, but I did not hear. I would request you pardon me on that issue.
We said one, what is employment? Then two, who can employ? Then three, how do we enter into a contract of employment? Then four, what are the duties and obligations of the parties to the contract of employment? Then what remedies are available in circumstances of breach? In circumstances of breach.
Thank you.
Both. Okay, so when you look at the first law we are reading is Article 40 of the 1995 Constitution. That article, that's what is in Article 40? Yes? Perfect. Okay. So we are looking at economic rights. Under Article 40, it says every person has a right. Every person has a right to be employed, We are looking at Article 40, the first law we're supposed to look at. It says economic rights. So it is very clear every person has a right to be employed or to participate in any trade or profession of his or her own choice. Okay? Then, after that, this when you look at that article, it says any person. So that means how many categories of persons do we have? We have two. That is to say artificial persons and natural persons. Okay? So as a result of that, there's two parties. Okay? So after that, we've looked at that article. What is in section 10 of the Contracts Act? Section 10 of the Contracts Act defines a contract. Okay? So someone read section 10 plus. So they have said that this must be, okay. So we shouldn't litter anything. They don't clean it again. Okay, that's why it was closed. So we say that the section 10 of the Contracts Act must take us to section 10 of the Contracts Act. Yes. Uh-huh. Okay, so section 10 of the Contracts Act says that is an agreement between two parties with free will and capacity to contract with lawful. So what does that mean? The question is known as employment. So we enter into an employment contract. So now we want to understand, we are still trying to understand what is employment, okay? But when you look at the law, the act does not define what is employment. But what we know, it is a contract. That's why we started with section 10, okay? So let's go to section 2 of the Employment Act. Section 2. Does it define the contract of employment? Yes? Does it define a contract of employment? Yes? Okay. If it is not called a contract of employment, how do they call it? Contract of service. So let us look for a definition of a contract of service.
Contract of service means any contract, whether on writing, whether expressed or implied, where a person agrees to written documentation to work with an employer and includes contract of friendship.
Okay, so when you look at a contract of service, this thing has always been creating problems. We have a contract of service and a contract for service. What's the distinction? Even before we read the circumstances that were run, you appreciate that. Okay, so from your reading of this provision, it is very clear. Okay, means any contract. Why? That's why we started with section 10 of the contracts, because this definition has the word contract. Okay, means any contract where whether oral or in writing, whether expressed or implied, where a person agrees. Who agrees to work? Employee or agrees to work for an employer for a lawful consideration known as. Okay, so now from that we have two people now coming on board. Okay, we have employer and employee. Okay, so what does that mean? The two categories of persons we looked at, okay, can be the employer or the employee. But we want to sit and ask ourselves, why do you think we have started with appreciating what is the contract of employment? So when you are reading other things, you have to first ask yourself, the facts that I have been given, does this person amount to an employer or an employee? Okay, so that means we have to first distinguish between a contract of service and a contract of service. So that takes us to what we call the tests in distinguishing a contract of service from a contract of. Okay, so these tests were set in the case of ready mixed concrete versus reading this. Okay, it is a very old English case. Contract 4. Okay, it is case number 1, ready mixed concrete versus Minister of pensions. Okay, so what happened in that case? Okay, Ready Mixed Concrete was a company dealing in concrete. So this company would make concrete and then it is taken to other sites. So it used to hire people with trucks to be sharing the concrete. So one day someone was hired with this truck. These guys could pay you per trip. Okay? But remember the truck is yours, you maintain your truck. So this guy worked for the entire week when he is not being paid for the trips he was taking. So then after, there is a day decided and said, today I'm not going to go there. Until they do what? They give me my money. So that day he didn't go, but his family got something to eat. Why? He got another gig somewhere. So he took his truck and did that gig and gotten money. So then after, he brought a claim against Ready Mixed Concrete, claiming that he is an employee who was entitled to the benefits of an employee in the company. So he wanted his pension as an employee, wanted all the benefits. So that's how this case of Ready Mixed Concrete came into. So Ready Mixed Concrete also sued the Ministry of Pension when it is defending itself. So in that case, the first thing to determine was whether this gentleman was an employee of Ready Mixed Concrete Limited. Okay? So as a result of that, court set out the different tests upon which you look at and determine that this person is an independent contractor or an employee. Okay? The literal meaning of contract for and contract of, okay? When they say for, they have hired you for that service that you know as you. Then of, okay, they have hired you, okay, because they know they have something that you can do for them. You get it, okay? If let's assume we've all ever dealt with tailors, okay? The tailor knows what. Nebwomugamba ndwagala ntya bamupapirako nebwobala ogenda okwambala ku Christmas ye nga mu program ye gyagambala ku bisooka ojjamuli. Why? Okay, is it for, you see, for what she knows? She will like you until you relax. Why? Okay, so the for and the of, they differ. So when we are reading the act talks of a contract of service, not for. So they hire because of a particular service, but not for your service. Okay, so the contract for is what we call independent contractors. So in that case, they set up different tests. The first test is we have the control test. Okay, we have the control test. The control test, when you are applying it, there are things you should look at. Okay, we have when, where, and how. That summarizes the control test. For you to be a self-employed or an independent contractor, you should determine when to go, how to do it, and where. If you don't have those three, you're not independent. Okay, I got exam at LDC here. Do the PAs determine what they are going to teach and how and where? The timetable is always drawn. That council measure will be in this class at this time. So he can't change the program. He has no control. Okay? So when you come back to the fact of that case of Ready Mixed Concrete, look at this guy. He could say since they have not given me money, the Rosidi apparatus, I won't go totally. That means he had control of when and where. Of when and where. That's why, because when he didn't go, he went and worked somewhere. Why? He had control. So that means he was an independent contractor, but not an employee. Okay? Then the second test that was set is, yes? Yes? We have the integral test. Integral test. The integral test basically refers to the degree of attachment. The degree of attachment you have on this entity. If you are not present, can the entity operate? Okay, so your absence, does it in any way affect the entity? Or it does not? Okay. Okay, integration. Are you integrated to this company? That if you don't appear, the company will not work. Okay. You remember the Mulago saga when the doctors and the nurses were striking? What happened to Mulago? Were the services being delivered? Why? These doctors are integrated. Their absence is failed. So the government failed the absence of these doctors. That's why they said we shall hire pro tuber. Why? They wanted to fill the gap, but the gap was heavy. Okay? So as a result of that, these doctors are integrated to the community. They can't do away with without them. Okay? So just think of it when the cleaners don't have LDC to clean. Will LDC close? Doesn't affect LDC. Just takes a few minutes when head backward stands and says, so we don't have girls here and wives who can clean. How can you sit in this environment? You will see people move slowly. They will clean. But let her come when the PA has not entered the class. Who will teach? You see, so the difference is integration. Are you integrated to this community or not? Your presence should be felt and your absence should also be felt when you are integrated to the company. Okay? Then our third test. We have people have issues. Well, what we call the economic reality test. Another that test has two names. It is called the economic reality test or the entrepreneur test. Okay? But some people, they differentiate the two. They say entrepreneur and economic reality is one test, but it has different names. Okay? So now, we are looking at the economic reality test. Yes. So you can find some books when they're referring to it as the entrepreneur test. Others may refer to it as, okay, the economic reality test. So it will be the same because the explanation remains the same always. Okay. So how does this apply? Economic reality test applies in circumstances where your survival solely depends on the money paid by your employer. If you don't have any other alternative, economically, you depend on that. That's why it calls economic reality test. Economically, one of the things we are always taught in Islam that terrible gaga mkozese. Every Okay? Teri Bugaga Mukozese. Why? If this person has not paid you, okay? When this person has not paid you, your children at home will eat beans and push proud. But the day the salary drops on your account, well, Mama Nat, you know, so that means economically your survival depends on this salary. Okay? So if the salary does not come, so you keep dying push and beans. You see, that's why the salary earner Amara Mugaga, we can't how this person will stock kosher beans and rice at home. So it's going to be something constant until the salary comes. But you, a street lawyer, who will wake up one morning, no over millions of beans, I just come wake up life. Just go, hey, see what goes on there. Okay, why? You don't have a program of getting money. So that means why? When you are self-employed, you become an entrepreneur. You think about money every now and then. But a salary earner is restricted to waiting the salary. So that what does that imply? That the economic reality test draws a line between an entrepreneur and person who is self-centered in the salary scale. So when you come back to our facts, Sentom, okay? When you come back to our facts, this guy who had a truck, was he economically depending on this company? The day he realized that I've spent a week without getting salary, he went and worked somewhere else. So what does that mean? In reality, economically, he wasn't depending on this. So that what does that imply? The economic reality test excluded him from being an employee, become a self-contractor. Economic reality test. How many tests are those? 3. The last test is known as the multiple test. I was told by the guy called Dr. Shaddad. Yeah. Okay, the last one is called the economic multiple test. When that was the last case, okay, in that case it has an appeal. So Lord Denning, in summarizing employment law, made that test and said all of these tests to equally apply. You should look at all circumstances. You should apply the economic reality test, okay? You should apply the control test and the integral test. Why? Some people may be self-employed, others may be paid employed, but when they have a lot of control, when they decide, when they are decision makers, but when they are not self-employed. So he said, for you to solely appreciate and all the theory and becomes a multiple test. Simple as that. So when you read that, you will be able to tell that the facts I have, these guys are employees or they are independent contractors. Economic reality. We say that economic reality looks at your income. Where do you derive your income from? The multiple test. When you are applying the multiple test, you include all the 3 above. That's why it's called the multiple test. It has economic reality, it has integral, and then the control test within one test. Okay. Yes. After adding the 3, you apply the multiple tests. So after when you apply the last test, it can give you right answer. Okay? It can give you right answer. This is the example. I was going to use an example, but okay. So now, after you've been given facts, okay. Now you are able to tell us, okay, the This is okay. So who can enter into a contract of employment? Who can enter into a contract of employment? This is what we call capacity to contract. Now let me ask you a question. Is there any law that bars someone from contracting? Any law? You can't contract. Okay. Okay. So let's start with Section 11 of the Contracts Act. I want you to listen to its wording very well. Okay. Okay. Section 11 of the Contracts Act. Yes. Yes. So the first thing you look at, 18 years and above. Okay. Another one.
I see not qualified for active by which people
First stop there. Okay. So the general rule is above 18 and of sound mind. Okay. Let's go to Article 21. Article 21. It says of the Constitution, all persons are equal before the law. So I want to exclude the people. All persons are equal before the law. Okay. Then after that, you know why we are moving like that? We have what we call special categories of employees. Okay. These guys can be employed, but when they are employed, they are supposed to be given that special preferential treatment. Okay. That's why you first look at the general rule, then you go to Article 21. So now, the general rule, we've seen it. So under the special categories of people, we have one, children. Okay. The first special category we are having are children. Okay. Children. Okay, let's look at Article 34, Clause 4. Article 34, Clause 4. Okay, we are looking at who can enter into a contract of employment. When you read Section 11 of the Contract Act, talks about capacity. That's why the general rule is 18 and above and of sound mind. However, Article 21 says all persons are equal before the law. Then after them being equal, the law went ahead because of Article 21 to create what we call special categories of employees. So when you see someone who has applied to be an employee, but when he or she falls under the following categories, that person is supposed to be given an opportunity. Why? We have the Equal Opportunities Commissions Act.
Article 21.
Yes. Okay, we are moving like this. We are looking at who can enter into a contract of employment. When you look at that, calls for what we call capacity to contract. As a result of that, Section 11 of the Contract Act talks about capacity, and it has been read. And when it clearly states that, okay, persons above 18 years and of sound mind. That's the general rule. But this general rule has what we call exceptions. Why do we have exceptions? Because of Article 21. Why? Article 21 says all persons are equal. Whether I'm a minor, whether I'm a person of unsound mind, whether I'm disabled, okay, you have to give us equal treatment, okay? So as a result of that, because of those different categories of persons, the law created what we call special categories of employees. These persons can be employed, but once you employ them, once you enter into a contract of employment with these guys, you should give them preferential treatment. So we had started listing the special categories, and the first category was children. Okay, so we are together now. So children, okay. Let's go to Article 34, Clause 4. Okay, it says, okay, Article 34, 4, says a child can enter into, it says children are entitled to be protected from social, economic exploitation and shall not be employed in or required to perform work which is likely to be hazardous or to interfere with their. Then when you go to clause 5, it says, for purposes of clause 4 of this article, children shall be persons under 16 years. Okay, so you see now, so the law has allowed that children can be. So if you are above 17, where do you fall? Okay, so we go on. Okay, so when you look at that law, it has protected children. Do you have any section in the Children's Act that talks about children? Which section is that? Okay. Okay, so it's around section 32. It's around there, I'm not certain exactly of the Children's Act. Okay, so now after that, because when you look at that section, it gives the minister the powers to enact any such laws for the proper employment of children. So then that takes us to what we call the employment of children is regulations. Okay, the employment of the children is regulations. Okay? When you read these regulations, they are very specific. Okay, when you read regulation 3, because the challenge is when you read the act, the constitution, it doesn't define what exact work. Okay, so the Children's Act, you look at section 32. Okay, section 32 in the Children's Act. Okay, when you read section 32 of the Children's Act, it says that children are supposed to be employed in light work. Light work. So the question is, what amounts to light work? What is light to you? A child from Kampala may not be light. The person, for a child from Masaka, no. What is light from the child from Ududa is not light to the person from Yega. Okay, so what amounts to light work? So when you read regulation 2, it defines light work to mean work not harmful to the children's health, work not harmful to the children's development, non-prejudicial to attendance of school, not in excess of 14 hours per week. So that means a child has particular period of time to work. Okay, 14 hours. It says, okay, not in excess of 14 hours per week. So what does that mean? In a week, a child is supposed to work 14. They work 24/7. They work 24 hours a day. Imagine. But if the law says 14 hours a week, okay, so if you are those are what design column we as a column. Okay, so now then after this, you look at section 4 gives the sum of the activities that are considered to be light. Now you're 1. Okay, regulation 4, okay, of the children regulations, employment of children regulations. 1. Aha. African children to do this light work, they may die. The first one, attending and serving guests. Aha. We have African mothers. See, they can tell. So let's read. You sit and see whether you don't breach the law at home. Okay, you bring mates when they are very young, 13, 14, but the type of work you give them, let us read. making purchase in the market or shops, looking for firewood, cleaning the toilets and bathroom, helping out in garden, preparing family meals, cleaning and polishing shoes, sweeping, cleaning the floor, and organizing the house. Okay. But you know the work they do. So you see, so whenever facts come, ask yourself, was this child given the right work? Okay. And the rest of the provisions are maybe also what you should look at what we call hours of work. You look at regulation 10, 11, and 12. Hours of work, how these guys, what within what time are they supposed to work? Okay. Yes. And 11. Okay. A child aged between 15 and 18 years who has completed his or her education or does not attend school may work up to 7 hours a day, but shall not exceed 35 per week. So that means within a day, a child below 18 should only work for 7 hours. For 7 hours. But you ask so about the maker. Okay. That's the law. Okay. So now, after that, okay. So ask yourself, after reading these sections, okay, we have case law that settles this position. We have the case of Nash versus Inman. It is broke, okay. Nash versus Inman. That case you see, this law only provides so that work which is not hazardous. But when you are defining the contract of employment, it has that last part and includes the contract of apprenticeship. What does that mean? Contract of benefits. Okay? We have two cases that have tried to explain that. We have a case of Wayne Rooney. This Wayne Rooney that we know, the former player of Everton and Manchester United. Okay? That case of Wayne Rooney. Okay? In that case, Wayne Rooney entered into a contract of training a particular kid to mentor him. So it happened. Rooney left this kid thrice, and when Rooney was sued, and he paid the compensation. Yes, he paid the kid. He was in breach. They entered into a contract. It was a beneficial contract because the kid was supposed to learn. So that's why when you go for clerkship, lawyers are wise. They tell you, here, no salary, no transport, but you have to work. Will you be here or not? Why? That is a contract of employment, which falls under a contract of apprenticeship. Okay, training, a contract of training. So a child can enter into that contract of training. Why? It is beneficial to that child. Okay. Okay, it is Wayne Rooney. Okay. Then another case is, no, we are talking about other circumstances under which a child can be employed. One where the contract is beneficial. Okay. So, mwabeta muzana abaana b'abantu bwana njagala abeere lawyer. Genda nga ne kanso obwana mubuleke. Okay. Wayne Rooney. Okay. Then when it comes to the case of Nash versus Inman, in that case, court held that a child can enter into any form of contract provided it is for necessity. So our act doesn't have those two. The other beneficial to the child, then this one is for necessity. So the question for determining necessity is a case-to-case basis. A child from Katanga, his necessities is very different from the child from Yenga. Okay? Yes. When you look at Inman, and Nash was this stubborn kid. The kid had a prom party. So he told the dad, I want a particular suit. The suit was damn expensive. So the dad bought him two. When he reached school, he saw another rich kid who took off a nice suit and said, Bandit, I need this. So the guy went to the family tailor and told him, can you make me this suit? I will pay. So the guy came with the third. Then after the prom, he didn't see the essence of having this suit. He didn't pay. So now Nash came to school to demand for money. When he reached school, they called the dad. They told him, your son came. I made an extra suit and he said he's going to pay. Now court was asking Nash that, to be honest, look at the circumstances. But when that case was argued, that according to the status of the child, it was a necessity. Okay? Hey, some of you asked for money for prom parties. Okay, you say, depending. Wama, did you attend any prom party? Yes, but none. Excuse me.
Only thing is but he didn't pay. And the father was complaining that he's greedy, and the problem he has the mother every time. And every time he drops into school, that's the problem to LTC. This is the environment that people are setting around. Yeah. He doesn't like it. With them, it's the generation of peace, man. Like they're swine. Like you see the generation. I love that. That's weird. But it's alright. Like you look at kids big already. All they know is and they're already a kid. Yeah. And we laughed. Oh, I'll never forget that. They told me to say it was about you. And I think I was my head. How the father was complaining. My father. Now we have 39. There's good words. Words of riches. So the mother was what does it say? Oh yeah, sorry, words of rich people. Rich people go for quantity. Sad, but we laughed. Yeah. I don't know why you're staying in now because most kids were home, no? Because when you are home 4 hours. The site called us yeah. What should we do?
how they perform before I even step there.
Yeah, you should. Because that is very necessary. You're in hostel. You come hostel. I did a bit how.
No, I have an apartment there.
You guys do want to stay around the school already. Even that's what came to the people. But Nana.
Noise, football noise, everything noise.
No, actually, enough for us to say you are in. Just we are at the donor part. All my own. That's the only thing is limited before. But it serves me at the end of the day, the voice of my brother who is very. So you want to consider in taking school, academic school, what?
Academics and morals. There's academics and there are no morals. But I don't mind food. I don't mind food. But moral. So come on, I don't mind morals.
I feel like even sometimes when you somebody that engaged in society or something, at the end of the day, so maybe the only thing I can fight regular you know,
Homosexual.
and it's school. I feel like the type like that, this age I'm ready to get like me.
They go for the kids, but me, I can assure you.
Wait,
Like, when the whatever, yeah, it's in a disclosed status.
I mean, when you take first course, your first course.
This one here, it's the first one. I like this meow meow. I like this meow meow. That's so pretty.
I'm ready to do it.
From Megan. It's so pretty.
It's like the coach tend to do that.
Yeah, it's so pretty. Oh, that's this one. Oh, very sweet.
And they need like the school business.
Yeah.
So funny how I don't like human beings.
Really? Who remember when you said yes?
I don't even know.
You know, people who are like, you know, you have plastic and it comes and goes.
Hopefully, but for now.
It's not.
Yeah. Rabbit.
Okay, so let's proceed. Okay, so when you look at all such circumstances, but when you look at the case of Nash versus, so when you are given facts, they will give you facts, they will include all the categories of employees we are going to look at. So once you have an employee, in your facts who falls within the first category. You've seen how this person, the type of work, okay, the time this person is supposed to work. It is when you are drafting the contract of a child, it should include all those. Okay. Then after that, you have another special category known as persons with disabilities. Persons with disabilities. Okay. Persons with disabilities. Okay.
Oh, where is it? Where is it? See, I've got paper. Attend me for ya. I'm going to want some chips. Yes. See, not something.
Okay. So when you look at persons with disability, yes, yes. Okay. For that, you must look at Article 21. Okay. Article 21. Article 21. Okay. Then you look at also the Equal Opportunities Commissions Act. The Equal Opportunities Commissions Act. Then you look at the persons with disabilities. Equal Opportunities Commissions Act. Okay. In its entirety. Okay, but you only want like the introduction. Why? All persons are equal. In case you have a matter I want to pursue, but I'm still looking for the mother of a certain child. This child will be enrolled in particular school or nation, and this person was sent away because this person has a disability. But I'm telling the mother, free of charge. No. A certain counselor approached me over that matter because we had some matter when I was still at campus. It was against a certain school, famous school in Kampala here. Okay, it has its headquarters in Gayas around there. Okay, Holmes Darling. Holmes Darling. A certain madam applied for the boarding section, but this madam had the child was an albino. So the teacher said no. He's going to scare other people. Yes, because remember at night the albino has issues. The eyes are glittered like gold. Okay, and he said that the albino is expensive to maintain, so they can't take this person in boarding. Okay, so but the madam said, I know how much it should be maintained. I will provide everything. But Article 21. So this madam approached the Human Rights Association from campus and they pursued the matter. You know how much the guy was given? That people, imagine, P7 was given a compensation of 50 million and full scholarship. Yes. In the body. So don't joke with that act. The Equal Opportunities Commissions Act is dangerous. It has that enforcement. So I'm telling this madam, you just come, show me the application form is sufficient to hammer the school. What? That's why it's called, it has what called the investigative team. They will go to the school, they ask, have you ever seen this person here? They will say, yes. Okay, when? They come to the records. If this person has ever come here, they will summon the person in charge of admissions. Trust me. At the end, they'll tell them, we either proceed or we give them money. and you choose. It's a simple matter within 1 month when you have your 100M on the account. Those things of human rights, you can shine for no good reason because people fear. Yes. Okay. So when you are looking persons with disabilities, you look at that law, then you go to what we call the Persons with Disabilities Act. So when you look at that act, okay, it defines a number of things, okay? Okay. Employment. And another example, there is a matter of IUIU as IUIU as sued. Okay? Why? They have the old law and the new law. The reason why they constructed the new law was from a particular suit. Okay? Why? They had someone with a disability. Okay? And this person could not access, so they gave him an admission. But the classroom was on the 2nd floor and the 3rd floor. So this guy had steps. He couldn't walk. So every time he could miss class because of that. And they sued. What happened? He graduated. He graduated. That capacity. Yeah. The guy used to buy material, he lives on his own. You know how it hurts. So after they constructed a new building without steps. Okay? Yeah. And the faculty was changed to this building to cater for him. Very simple. You see this here. You see those why those things are new. Have you realized? These steps were the first ones. After realizing that, they also constructed those ones. People will. So once the reason why all buildings have lifts, not to ease work, no, persons with disabilities. That's the essence. Okay? So once you are an employer and you employ someone with a disability, okay, make sure you cater for that disability. So disability is a case-to-case basis. Okay? So when you look at this act, it defines, it gives all the rights of a person with disability. Access to a building, access to justice, okay? And then they have their council. It's a bit not so big, okay? Yeah, not so big. You refer to it, okay? But what you should know, what they want, okay? Respect and promotion of rights and freedoms of persons with disabilities, section 3. So why? If they say that respect and promotion of rights, Article 40 provides for economic rights. It says all persons, inclusive of persons with disabilities. So when you look at section 3, it says the government and all persons in Uganda shall respect, uphold, and promote fundamental and other human rights and freedoms of persons with disabilities enshrined in the Constitution. Okay? So after that, they go on giving the different rights. Remember in COVID, there is a guy who has been caned, known as, okay? He said, I left home, my wife has given back 2 weeks. I sell perfumes and this person in here. So you want me to go back home? What will they eat? So you either beat me and kill me from here. But I'm not going back home. My child has to eat and the man choose. The guy refused, even he sat down. Now the police officers, they knew the act. They can't enforce anything against this guy the way they enforce to the normal person. The guy sat down. They couldn't beat him. Yes, he was disabled. They couldn't beat him. They couldn't drag him anywhere. So what they did, they just stood there by force. They also stood. So no one will come and buy from him. They don't touch his things. They know if they did it, it could be an offense. So they just stood there. So that those who would come to buy, when they say for instance, like, I was glad. So just after one day, the complaint went to human rights. Within 2 days, all the human rights activists in Uganda, they made a shop for him in Nampula. They paid rent for 2 years. Mobit came and gave him stock. Free of charge. The wife was also given a business. Free of charge. Those are human rights. Okay? So once you get a contract of employment with a person who is having a disability, just know you have to come to this act. You cater for that person is. There is a case, but I'm forgetting the parties. It's also an English case. Okay? That case, this guy was carrying on welding business. So this guy came when one of his eye was affected. It was a spoiled eye. So he had one eye. So when he came, they never gave him protective ears and the glasses. The reason they gave that the glasses were done. Then there are only 2 pieces, but those 2 pieces were already booked for persons without any disability. So the manager said we can't give them away. So what happened? During the process of welding, this guy damaged the second eye. So he became blind. They sued the company for negligence. Yes? No, these things that come out of the metal, so it hit his eye and it also got spoiled. So the guy became blind. But why? So, but if this guy had looked at this law, that person was supposed to be given first priority. So you employ special categories with a keen eye. Another category, the third category, expectant mothers. Okay? Expectant mothers. Okay? Expectant mothers. Now I have a challenge with certain institutions. Yeah, there is security companies. Once you conceive, you say bye bye. The security companies. Okay? Yes. Okay? The security companies. Once you conceive, why? So then what does that mean? Expectant mothers, they don't have a right to employment. You see? But once you go and talk about that matter, you know what the defense they have? They say it is in the best interest of the expectant mothers. That's what they say. Because the type of work requires them. Okay. So the expectant mothers, they always say it is in their best interest. But when you look at the law, they also fall under Article 21. They shouldn't be discriminated. I had also media houses. Once you get pregnant, why? So, because the figures change, you can't appear to be attractive. Okay? I depends. Okay? So I don't know. So once that's why that explains why we have maternity leave. That explains why we should have what we call resting places at the workplace. Even they should be accorded what we call resting hours at work. That's how it's supposed to be done. But this law of Uganda, we have good laws, but enforcement. Jangu company mfusendiri kuti ompumuddemu ajja kubuuza bakali nakutumako obutumu. That's the hardest part. Even government institutions, for them, they let you work, but sometimes they do regulate. But you find some strict institutions, Zoremo. Okay? So when you look at that, that's why when you go in the bank and the extracted mother comes, he passes by as if there is no right. Yeah, these are the benefits of getting pregnant. But yeah, hey, that's our jam. Okay. Okay. So, do you have any other special category? Okay, they fall under disability. So, yes, yes, Professor. Okay, so now, okay, yes, disabilities, yes. Okay. I mean, I'm going to assess. We have what we call our conjo. Not all of them. They have that. That's what is non-stop. Yeah.
And I've got little people.
Yeah. Stop. Let's get back. And let's get back. Okay. He's referring to what called little people. Okay. Little persons. Okay. You see them. Okay. They're called little persons. Yeah. Yeah. Okay. It's a disability. It's a disability. Yes. Okay. Let's get back. Let's get back. Okay? So now, then, okay. Okay, so now we presume that the person you are having has capacity to contract. Okay? The person you have has capacity to contract. Now ask yourself, how do we enter into the contract of employment? How do we enter into a contract of employment? Okay? How do we enter into a contract of employment? Okay? Can you read for us the definition of contract of employment? From that definition, contract of employment, which is contract of service. Okay? It says
Contract of service means any contract, whether oral or in writing.
So the first mode of entering into a contract is oral, by word of mouth.
Section.
Okay? That's the first one. By word of mouth. Another one?
In writing.
So that means in writing. So we are going to first look at in writing. So if it is in writing, that means we have to draft a contract of employment. So that takes us to drafting a contract of employment. How do we draft a standard contract of employment? Okay? So now, for you to draft a standard contract, you have to first ascertain the category of employee you are intending to employ. Because you draft a contract not putting into consideration that the employee you have is a person with disability, that the employee you have is a minor. So all what you do, you draft the standard contract. Okay? So that is the first thing. So what are the contents of this contract of employment? Okay? Now, the first one is the contract a public document or not? Why is it a public document? When you look at section 60, it can be used as evidence in court. Section 6 of this Employment Act, it can be used as evidence, not so? Because it says a contract is conclusive evidence. Conclusive evidence. So why? Isn't it a public place? So by virtue of that, you start with the Republic of Uganda, because a contract is a public document. Then we say, because in the definition, it talks about a contract. So which of our contract? Then you say in the Contract Act. Okay? Then the matter of the Contract Act. After the Contract Act, what is the mother law in employment? Then you say, and in the matter of the Employment Act. Okay? Do you have any other law you want to relate to? The answer is no. Okay? Then you give it a heading, Contract of Employment. Contract of Employment. Okay? Then you can say, this contract is made this day of that and that. Okay? Then you give us the recitals. Okay? You play it twice. Okay? So, we've said that after the heading, Contract of Employment, then you say, this contract is made this dash day of this. Okay? Then after that, we want to see what follows, what next. So from there, everything that should be in that contract is in the Act. Council, take us to section 59. So once you draft your contract and these contents in section 59 are missing, that means your contract is wrong. Now the challenge is they didn't give you a format. You get it? They just gave you what you should include. Why? It shouldn't be standard. Okay? Yes, of the Employment Act. It says written
particulars.
You see? So that means whatever a written particular is the contract of employment. The written contract. So that means these written particulars include the following. So these are the things that include your contract. Okay, let's go.
Subsection 1 says an employee is entitled to receive from his or her employer notice in writing of the following particulars of employment.
Yes.
A, the full names and addresses of the parties to the
So
contract.
that means after the one, okay, this argument is made this 24th day of April 2020 between one, including the first part, okay, trading this and this limited, okay, and you could include the employee, employee. Then after the parties, what else?
The date on which employment under the contract began.
Okay.
Specifying the date from which the employee is
so, see, you will read that provision until the end. Okay. Section 59. Okay. You will read it. Make sure if the facts need drafting a contract of employment, it should follow that format. Okay. All the contents therein should appear in your contract, but with the necessary. The reason why it is not a standard form, because we employ different people. Okay, we employ different people and they are in different categories. So they give you the things you should incorporate. So you incorporate them according to the type of employee you intend to employ. Okay, so now we presume the contract has been drafted and signed. Once a contract has been signed, when you read the case of, we have a famous case we cite here. It has one of the parties as Shell Uganda, okay, which says that where a contract has been signed, it creates duties and obligations binding on both parties. Okay, it is Kasibante versus Shell Uganda Limited. So after this contract has been signed, I'm using the word signed, not mere drafting. So once you sign, it will become binding. To who? Now you've become an employer and an employee. Why? Okay? You have entered into a contract of employment. So now, let us look at who is an employer and who is an employee. Okay? Who is an employer and who is an employee? The definition section. Who is an employer and who is an employee? Imagine this question, it is known as labor law 1 and 2. You're doing it in just one day. We are getting there. Okay. Okay, so let's read the section. Remember, let's get back, okay? By 9, we should be leaving this place. Those are the directives we have, okay? An employee,
Employee means any person who has entered into a contract of service or an apprenticeship contract, including without limitation any person who is employed by or for the government of Uganda, including the Uganda Public Service, a local authority, or parastate organization, but excludes a member of the Uganda People's Defense.
Now, with the exception of the UPDF, the rest are employees. Okay? Section 2, the definition section, defines an employee. UPDF, they are not employees. Okay? Okay? They are service providers. Okay? They don't fall anywhere. Literally, they are doing pro bono service because they serve the entire nation. They don't fall under anywhere. They are not under public service, they're not under private service. Okay? Okay? We've said, okay, the definition says all persons employed in the local government, any government parastatal, all persons employed through public service are employees, with the exception of the UPDF. You ask those guys in UPDF whether they have ever signed any contract. They don't sign contracts. Okay? You just go, you train very well, come back with your gun. Okay? So that's the life. Okay? Then, okay, but then after, let's look at the employer. Who is an employer? Who is an employer? Can you read?
Employer means any person.
Are you guys hearing?
Employer means any person or group of persons, including a company or corporation, a public, regional, or local authority, a governing body of an unincorporated association, a partnership, parastatal organization, or other institution or organization whatsoever, for whom an employee works or has worked or normally worked or sought to work under a contract of service, and includes the heirs, successors, assignees.
Okay, so now when you look at that definition, it says an employer, okay, means any person, okay, including a company, those are private companies, okay, a corporation, a public, okay, a public entity or an association, okay, or any other entity, okay, or any other entity, okay, to which an employee has worked or is working for. Okay, so what does that mean? Literally, an employer is a person who employs an employee. An employee is a person who works for an
Employer.
That's English. Okay, so now the presumption is we have entered into contract of service Now we have become employer and employee. As per the case of shared versus shared market, the contract constitutes an. So where there is a duty, there is a right. So let us go to rights of employees. Abakozi. Okay, rights of employees. Okay, rights of employees. Okay, can so read for us section 59. That's where the first right is. Section 59. When you start like this, remember you have now become an employee. So every section we are going to read has that word, the employee, the employee. You're going to mark it. 59.
Subsection 1.
Yes.
An employee is entitled to receive
From
his or her employee
a copy of written. So what right is that? A right to receive a copy of the contract of employment. What's the cover for Chinese staff and here? Do they give just a copy? Do they give a copy? You know what? You know why? No. You know what? They are good at violating the laws of employment. So why? Once they don't give you a copy, you have proof that you are the employer. And those guys don't give IDs. They give reflectors. They know they violate laws like nothing. Okay? Why? Cancel with section 60. Once you are given a copy, what is the essence of giving you a copy of the contract of employment? Yes?
written particulars to act as evidence.
Stop there. Okay? Section 60. What the law says, the first right once you enter into a contract of employment is to receive a copy of the contract. But the Chinese are very wise people. They know. Because if we give you, once you take us to court, you'll adduce it as evidence. So they said, no, we don't give them. Even if you ask for it 1,000 times, they are wise. They don't. So how are you going to prove that you worked for them and they are in breach of contract? Because once you say breach of contract, you should attach a copy. So what are you going to attach? You have evidence. They don't waste their time. Okay? They don't waste their time like that. Okay? So now, another right. Okay? So the first right you said is a right to be given a copy of. So they will give, now mark this. They will give you facts where all the rights we've seen have been violated. Okay? So let's go on another right. No, I was just referring why that should be there. Okay? Then another right. Another right. Let's go to section 40. Another right. Another right. Section 40. Yes. So where we say where there is a duty, there is. So that means what right is that? A right to be given work. Okay? A right to be given work. Now, we have a principle of redundancy. Have you ever heard of it? In law firms, they make you redundant. They just make you redundant. They don't give you work. If the employer has not given you work, but impliedly, so you have a right. So if your right is violated, you exercise the right to. Law firms, they don't want to be sued for unlawful or unfair termination. So what they do, they cease their duties as employers. They stop sending you. They don't. They are getting anything. You put on your castle every day. You come. You sit, you drink water, you go back. Come the following day, you drink water, you go back. Then you start thinking, yeah, if I keep on going here, what will happen? So because an employee has a right to be terminated. Now we terminated. You see, that's how law firms operate. So make your own firm so that you're not be. So once the employer starts not giving you up, you'll be redundant. So that principle comes from this redundancy. Okay? You try to sell law firm, you will see. Okay? Then another one, under 41, a right to be given wages. 41. Council, let's read 41.
Section 41.
Mm-hmm.
Entitled pay for wages.
Uh-huh.
Section 1 starting with subject to employee. Wages shall be paid in the equity that to the employee entitled to pay.
Now, let me change it. When you see section 41, is a bit wide. Okay? Remember, this is one of your last classes to always. Please pay attention next week. Section 41 is tricky. They are saying that you have to be paid wages, but in what? What is our limitation? Uganda fees. Okay? But we have other legal tenders, not so. As a result of that, they will give you facts and tell you that Rashid is an employee who is employed by Mr. Daniel. Mr. Daniel is a wealthy man with 4 farms, one in Mugende, Kasanda, another one in Masakanyendo, another one within Kampala, and another one in Karamoji. Okay? After Rashid executing his duties diligently, when he went to demand for money, okay, he was told that he should pitch 4 cows from the farm. Is that legal tender? You see, it will be breach. But indirectly, this person, okay, is breaching the law. That you have a right to be paid, but the payment, the section uses the word shall in legal. If not, they'll tell you the boss told him to take his old car instead of the salary. You get it? Why? The boss is not paying illegal tender. Council proceed with the same section. There is something. So regardless of the fact that you're supposed to be paid wages, how and where? How and where? Okay, that is key. Council proceed with 41 as well.
Notwithstanding subsection 1, an employer may, with the prior written agreement of the employee, pay wages by bank check, postal order, money order, or direct the payment to the employee's bank account.
Oh, but all that payment is illegal tender.
Subsection 3, notwithstanding anything in this section,
Mark that. I told you whenever the law says notwithstanding anything, what does that mean? That this is so paramount. Put a lot of emphasis here. Proceed.
the minister may, after consultation with the labor advisory board,
Mhm.
by regulation provide for the partial payment of wages in the form of allowances in kind, and in no case shall alcoholic beverages or noxious drugs to the industries or occupations in which payment in the form of such allowances is customary or desirable for the personal use of the employee and his or her family, and the value attributed to such allowance shall be fair and reasonable.
You see? Why? When you read that, basically, those are shortcomings that an employee may face. So these guys, when you have a problem, they tend to find means. Okay? Government has Daniel, Those things happen. But when you don't know, okay, you feel extremely happy. No, you are ended, it's fully happy. Okay? Yes. But again, when you proceed with that section, it tells you places where you should be paid from, not so. Have you seen it? Places where you should be paid from. Guys, have you seen it? Okay? You should not be paid in places where ewali okuchakalwa, okay, we batunda omwenge or anything of the sort. You know why? Bosses are wise. Ajja kuba yakola ebbaala abayiti abawa omusaala mu bbaala wennyini kakasa mujja kulekawo. You think the framers of the law are stupid? Nawe akabaaki bakolako nekibaluma. You get it? If I'm the employer, I have a place, Musange Kabala. Automatically, once you get money, you're going to get excited. You're going to spend 90% of that salary in that place. As it is, as simple as that. Okay? Yes, it's wide. You see that section is a bit huge. Okay? If not that, even if it's not in your place, some employers are funny. They make end of month parties. Have you realized that? And some others make end of year. They find means of taking your salary in a very wise way. They say, you buy shirts on my salary, on your child's birthday, so you see, okay? So under that, the law is very clear. Because they know if you are paid in a place where that such things happen, you're going to get excited. What are you going to take home? So the law has prohibited payments from such places. So when you see facts, they will show you where this guy has been paying this guy's orange. And you don't put a keen eye on that. Okay? So that is also, that's why they say, deposit on his account, open buyer, box, or give him cash. Where? At the workplace. It don't cause problems. Okay? But those guys, they pay at the time when the buy is not open. Yes. Okay? So, then I don't know, I'm mostly okay. So then another right, okay, another right, you have a right to disallow unallowable deductions. Okay, to disallow. Or you also can. Why? Some employees deduct your salary for things that are not provided for under the law. The law has provided for what we call allowable deductions. That is your right. You have a right, okay, to save the allowable deductions. That is NSSN. That is your right. But that is the allowable deduction. But employers are funny. They force people to save. They have got wano ate simanya birthday ya bundu tugenda kugula t-shirts tutema ku misaala bwe basagala kwambala t-shirt eriko mu kifaananyi kya mutabani we oginsibako contribution simanya for end of year party they deduct on your salary. Those are non-allowable deductions. Once you see it, scream loud and run. Okay? Yes, sir. Yes, that is okay. But some people don't consider that support. That's a mode of enforcement. Okay? That's a mode of enforcement. We shall see whether it is applicable as well. Okay? Yes? The law that because you consented in your agreement, you first go back and do the agreement and you come back. Okay? Yes. So now, when you look at deductions, okay, look at section 46. It says the following deductions from remuneration due to employee are permitted. So section 46, if the deductions are not under 46, don't allow. It is your right. It is your right. I am not. You know, to be something one way. The person who understands how to obey, that person who has been go home without work, okay, for some good time, okay. So then another right, a right to enjoy leave, a right to enjoy leave. A right to enjoy leave. So we have different types of leaves, not so? We have, that's why we look at annual leave, maternity leave, okay, sick leave, all of those, okay. So you put them under, but each leave is a different right. You get it? They say give us 10 rights of employees. 1, a right to annual leave, a right to sick leave, a right to maternity leave, a right to paternity. Okay? Those are all different rights. Okay? We have also another type of leave, but it is at common law. Okay? When you lose someone, a relative, there is what you call, how do they term that leave? Okay? But enforcing it here is a problem. It is called compassionate leave. Okay? Okay? You see, it wasn't incorporated at first, but when they amended, they included it. But this Uganda, okay? You look at section 41, but okay, section 41, subsection 6. Okay, 3 days. No, that means in the whole year you enjoy it. It is limited to 7, but each time you have 3 days. That means mumwaka ofira mweki. Kati mwabafiwa abaganda. Zineiba nafa omwana wakojja wange gwe yasikira oli enva gwe yaluma. Okay. Then another right, a right to join trade unions or labor unions. A right to join trade unions or labor unions. It is under which article? Okay, you start with the Constitution first. Okay, it is under which article? I can't see what I do. Okay. Okay. It is under which article? Okay. It is okay. It's the right association. Okay. The Constitution is known as the right to association. Okay. Which article is that? As I have the Constitution with you. Okay. The right to join union. Article 29. Okay. Okay. Then under the Employment Act, Article 29 of the Constitution provides for a right to join trade unions. Okay. Under the Employment Act. Do you have that provision? Okay. Okay. Then you go to the law known as where's it? Okay. The law is known as the Labor Unions Act. Okay. So you have a right during the labor union or unions, but it should be a registered union. Why? Okay. Why? You have what you call common bargaining power. You see teachers. They see that teachers sounds money. Okay. Science teacher. As teachers, they're not considered. Okay. So you see that that's what we call. Okay. Then another right. Another right. You have a right to compensation. A right to compensation. A right to compensation. Under which law? The Compensations Act. So you should be able to appreciate under what circumstances should an employee be compensated. Okay? That's the one. Okay? The Compensations Act. Okay? Okay? Then after being compensated, okay? No, it won't. Okay. Then another right, you have a right to a clean and safe environment. Okay. A right to a clean and safe working environment. Under which law? The Health and Safety Act. Okay. Yes. Even the Constitution. Okay. Then you have a right to be given protective gears, also under the same law. Okay? Okay. Then another one, a right to weekly rest. Then, by the way, it allows you should have a day you rest. Those who have worked in banks, they can testify. That one is mandatory. But people can, people they know that they pay extra. So what are you gonna do? Okay. Then that is under section 51. Okay. Then section 51, the right to weekly rest. Okay. Yeah, okay. Then another right we have, you have a right to terminate. You have a right to terminate. Now what you suck up for? Why? You have a right to terminate. Okay. We still have a lot of rights, but let us do the cause of those rights for certain reasons. Okay. So now, whatever you've seen is a duty of the employer. Okay, you get it? So they are interchanged. Yes. We still have okay. Let me highlight all these at once. Okay. You have a right to be repatriated. Repatriation. A right to repatriation. No, you shall read the law, you will appreciate it. Okay. A right to repatriation. What is repatriation? Once your contract has come and end, you should be taken back from where they got you from. Yes. Okay. But that right is not exercisable at all times. It has conditions. Which section provides for it? Okay. When you read section 39, it says an employee recruited for employment at a place which is more than 100 kilometers from his or her home shall have the right to be repatriated at the expense of the employer. So now, what one kilometer? Once you enter Oros, they will tell you, Rashid went to Nasana and picked 150 boys who have been working in this company and boys. However, their contract has been terminated. These boys are furious. They want Rashid to take them back at his own expense. Cancel proceed. Kadolokwa wasoma kanu. From Kabube to Nasa, how many kilometers are those? Okay? How many kilometers are those? But the law requires 100 kilometers. Okay? How many kilometers are we have to 80. That means even from Kenya, we don't repatriate you. You see now. So once they say they came from Lila, you get it. From Lila to Kampala, it is beyond. So you don't even waste time. Okay? You see, you have another right. Okay? Yes? If it is here, you repatriate them there and then. Okay? Then you have another right, a right to seek pay. A right to seek pay. Under which section? Section 50. Okay? So you have to bid. Okay? Seek pay. Okay? Section 55. Okay? You have to be paid. But that sick pay, it has a time where it ends. Okay? Okay? So you should be able to read because they'll give you facts when the sick pay ended at a particular period of time. So you should be able, when you're reading this law, to tell when does it end. Okay? So that you don't fall a victim of poor interpretation. Okay? So when you read the section, it says an employee has completed not less than 1 month's continuous service with an employer and who is incapable of work because of sickness or injury is entitled to sick pay as follows. The first requirement, or you should have spent more than 1 month at the workplace. Wakaja olwokuba obuterira environment ye Kampala tozitegeera n'oli ekikomando n'olwala mu weekend wejjanjabe. So you say at least 1 month, but when you go on, okay, they go on giving you other, so that they tell you for the first month's absence you are entitled to full pay. Omwezi bwe guyitawo, for the expiration of the second month in sickness of employee, the employer is entitled to terminate the contract of service. Yes, so you get it. Once the second month expires, we terminate to the. You see, okay, yeah, okay. So we still have other rights in Pola, but those rights are so pertinent. So whatever right we've seen is a duty of. Now we presume the contract is on and everyone is enjoying his or her rights and duties. However, during the course of employment, things cannot be the same. Okay? The employer neglects problems, okay, and decides to sell the business. Okay? But where does that leave you? Okay? So that takes us to what we call transfer of the contract of employment. So you can transfer this contract to her. So we have two things. We have transfer and continuous employment. Okay, so we are looking at transfer and continuous employment. There are things you look at. They will give you facts where Kakaire is an employer, okay, who is employing Aisha. Then Aisha is imprisoned for something not related to work. On the face of it, oyo bamusiba katuteekewo omulala. What does the law say? Okay? Imprisonment on something not related to work, your contract doesn't come in. Known as continuous service. Okyaliwo era omusaala olina ogufuna. An example, look at Segiri. He has been imprisoned, but he was receiving his continuous employment. So there are things you look at. An ordinary person will think that this contract has been, but the law says no, it is still continuing. So we first look at continuous, then we look at transfer. Okay? So because, yes, but the law, let's read the land you see. Okay? Yes? Yes? You have what we call a social contract council. MPs are a social contract. Yes, they are employees of the public. Okay? Okay? So let's go to continuous service. Which section provides for continuous service? Yes? Which section provides for continuous service? Okay? Representation criteria, industrial action. Please note this right. A right to industrial action. Okwekalakasa. It is a right. Mulina okwekalakasa. Abakozi. Sigamba aba LDC. Okay? Okay? It is section 76, industrial action. Okay? Section 76. Okay? Okay? So continuous, we go to under section 82. Okay? 82. We have continuity. Okay? So it says that continuous service shall begin from and include the first day on which an employee begins to work for an employer and shall continue up to and include the last day on which work shall be completed. What does that mean? And your contract is formally terminated, we shall presume that you are continuously employed. But we want to understand what really amounts to continuous employment. What things do you look at and we say this is continuous, that the contract is still continuing? Section 83, definition of continuous service. It says, subject to the provision of this section, continuous service means an employee's period of uninterrupted service with the same employer. The same, what does this mean? Okay? The time you've spent on work with the same employer uninterruptedly. If she's the human resource, okay, and we upgrade her to the director, is that continuous service or not? In the same institution, she has been the human resource. We've upgraded her to the director. Is that continuous service? Why? It is continuous service. Her contract has not been terminated. Categories are one director, one human resource. This is something. The contract continued with the same employer. But if she goes to another entity, that means the contract has come to an end. So now, okay, let's go to section 84. It says an employee's continuous service shall not be regarded as broken where an employee is absent from work on the following circumstances. They will give you facts. They give you the circumstances mentioned under section 84. On the face of it, the contract looks to have been terminated, but that contract is still continuing. You are absent from work, you are not working, but you are not interrupted. You get it? So the first one, once you see this, it is not termination. You are still unemployed. Okay. 1, due to his or her taking of annual leave, study leave, whatever. Okay. Whatever type of leave, that is, you are still unemployed. So that is taken to be continuous. Then suspension, with or without pay, you are still unemployed. Then C, temporary laying off. This happened in COVID. The rest we shall see after. But it is what we call laying off. Okay, laying off. Naye omanyi pressure ebeera amagabumula ng'obadde oyina wamuwokka pressure ogimanyi olaba bagamba enkya toyijjira. Then due to strike or lockdown, so ne bwe tuba tulika sit down so tetujja kukola mwe mu striking ekwano mulala. I'm lying, don't take my words. Okay. Okay, then I'm so much interested in it. Okay, due to a sentence of imprisonment for an offense unrelated to his or her work. Okay, you are a teacher here. You get it? Once they imprison you on anything unrelated to your work, the law doesn't allow to terminate. Or God serve your sentence and come back. Amen. Yes. But the Lord said that. Okay. So it is a case-to-case basis. Okay. So now, are we together? Okay. So whenever you see such things happening, that person is still an employer, so he should enjoy all the rights of an employee. So then, if it is not continuation or continuance of service, we have to look at what we call transfer of employment. What amounts to transfer? Okay. Transfer of employment. Embaga ya Airtel ne Zain. Okay, have you ever heard of that? That's what we are going to look at. Okay. Okay. So when you look at section 28, talks about transfer of a contract of employment. Okay. Is it? Yes. Transfer. What does this mean? If I have a company, I have employees, and I sell transfer. Okay, the person who takes over should treat all my employees the way I have been treating them. You don't change, you don't terminate, you don't change anything in the contract. Once you do it, it's an offense. You saw what happened there. The bank was no. Okay, you see what happened to DFC and Prempa after the takeover? Everything continues the same way. That's what we transfer. Once you transfer my contract, it goes with all duties and the same way. The same thing. Okay, the same way. You get married to a man who has children. Okay. You have reads. Okay, it is a transfer. Okay, of duties and obligations. Okay, you are human with the same way you marry a single mother, take her the way she is with her children. Okay, benefits, it is okay. Okay. If you found her when she can take care of her children, why did you birth? She was in peace, now you want to leave her in pieces. take her with all her children. Okay? So, then the section says that except as provided in subsection 2, a contract of service shall not be transferred from one employer to another without consent of the employee. Section 28. Okay? Literally, if you know now, we're going to do business, just kind of understand. Business together to kids and woman. Where are you going? The law is very fun. Okay? So once they agree, then you sell the business to someone else. Okay? The law says the transfer shall be unlawful without consent of the employees. Unless you follow the procedure in subsection 2. Okay, it says where a trade or business is transferred in whole or in part of contracts of service of all employees employed at the date of the transfer shall automatically be transferred to the transferee and all rights and obligations their own. Okay, unless the agenda of the business sale, omusala enyambala that's the law. Okay, so when they give you facts, when someone took off a company and made changes in the contract of employee, it is a breach. You sue. The employees, you can see. Okay. So now we presume that we transfer everything. Okay. And as you know, life will never be the same. Okay. Life will never be the same. At the end of the day, you can bring this contract. Okay, that takes us to what we call discharge of the contract of employment. Discharge the contract of employment. Okay. Discharge the contract of employment. Okay. So when you look at discharge is bringing the contract of employment at the end. What are the different ways through which a contract of employment can be brought an end? Okay, there are 2 ways. 2 ways. So the first one. There are 2 ways. One is termination. Okay, termination. The second one is dismissal. That is the most confusing part in this first unit. Okay? The first one is termination. Another one is dismissal. There are only 2 ways. Okay? We shall get there. Don't worry. Okay? So now, let's look at termination. First things first. What is termination? Answer, take us to the definition section. Okay, termination.
Termination has the meaning given by section 65.
Then go to section 65. Now we are now. Okay.
Section 65, subsection 1. Termination shall be deemed to take place in the following instances.
Now, before you look at the instances of termination, ask yourself, who has a right to terminate? Okay? Who has a right to terminate? Who has a right to terminate? Who has a right to terminate? Okay? Both the employer and the employee. Both the employer and the employee. Okay? So when you are reading section 65, understand under what circumstances does the employer and the employee? That is key. Okay. We go on. So when you are looking at this, that basically for you to appreciate this, these are known as types of termination. So there are different types of termination. Okay. This is the hardest thing in employment. Let's first look at the normal ones we know. One, death. Okay. Death terminates the contract. Okay. 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 Another one where the contract was of a fixed period of time. Okay, lapse of time. Ezo ziri common tuzitegeera. Mpola. Okay, another one is neza bulijjo. Okay. Losing capacity to contract. Okay. Losing capacity to contract. Okay. When you become insane. Okay. Or where a suit is against you, you are declared, the company may be declared bankrupt, or the employee. Okay, on a personal basis, you are declared bankrupt. Once you become bankrupt, you cease to have capacity to contract. So the contract will come to an end. Okay, those are common ones that we know. Then we have termination by notice. Termination by notice is under 65. But that notice is a case-to-case basis. The law is, okay, so we look for that provision on notice under 65. Okay, section 65, subsection 1A, it says,
where the contract of service ended by the employer with notice. B.
Okay, stop there. Why? In your contract of employment, we have to include period of notice. That in case you are to terminate my contract, you should give me a notice of how long, maybe 3 months or 3 weeks. Okay? Now, what happens? Have you ever heard of what you call payment in lieu of notice? Okay? I'm using this example for academic purposes. Okay? Manchester United. Huh? The former coach. Bang again. Without notice. That notice was insufficient. But you know, those clubs, they value the supporters and even the players. So what the supporters wanted, so the club had terminated without notice. Okay? Without notice. So the impact of that was to pay this person in lieu of. You get it? So they'll give you facts. They give you a copy of a contract of employment. Normally we notice. So this person's contract will be terminated. Insufficient notice. Now, when you are representing the employee who was terminated, this is unfair termination. Or to call remedies. What remedy do I see? But they gave you when the answer is on the period of notice. Because the remedy you have to seek for is an order for payment of lieu of letters of administration. Okay, you get it. So, but at the same time, okay, on that issue of notice, even the employee you should give notice to your employer. Wali okuteka ewaka nolekayo maybe nosanga ng'agenze. Bigana kaana kasiru. You see how it pains, eh? Imagine you left this maid is your employer. You see the victims, okay? You give her money to cook food. Transport. Why? She lives without notice. Now, so musango unlawful termination. Yeah. Huh? So you see, you are committing an offense. You are employing people who are not supposed to be employed. You see? Yeah. So we go on. So if not by notice, okay, we have another one, another type, which is known as constructive termination. Constructive termination. Tebagamba, okay? Tebagamba. How they do constructive termination? They terminate you will never see them. Yeah? You start seeing. So we no longer hide status view. We just post whether you die, you die. Then you start another status. Hey, the new Mina. Yeah? Then after they post another image, I feel like post travels. El Napo Mao. No sending a message in Waka Blue Tiki. Then when you send the money, they say, receive the tax. You see, construct themselves. Okay, constructive so. When you read the case of our famous general, okay, versus AG, which general is that? Efunza versus AG. Okay, this happens where the employer has made it difficult for you to perform your duties. Okay, for you to perform your duties. Okay, for sure, you know I'm an associate in your firm. I'm under an obligation to do the following. Then every day, see I'm the assignment. You see, you become redundant. Once the law firm makes you redundant, constructively, gender. Okay, that's what we call constructive termination. Oh, really, this is no longer beneficial. Kindly disappear. Okay, disappear. Okay. Okay, so then another type of termination without notice. Termination without notice. Who has the right to that? The employee only. The employee has that right. How? Okay. Once you give me a notice that you are intending to terminate my contract in 3 months, I don't give notice. I don't. The law allows you to just disappear before the expiration of the notice. Now let me tell you. See these creatures, they are very wise. Once they realize danger, they say, she creates drama up and down. Says, Jeff, it is okay to chimare. Only Jeff wanted to end the relationship without notice. They easily realize danger, but they don't want to be in danger. So what they do, they disappear fast enough. Namutira mu firimu ye. You get it? So once in employment, once you are given a notice, okay, that 3 months, I'm terminating this contract, start looking for an opportunity. Once you get it before the expiration of the notice, don't see it. Those are one another. Mwesanga ku court nabwo defense counsel na we need to understand. There are meetings in serving over on serving sina mudde. Wait, era na ana kata kusekana singa nakaleka na akansala consent. Twabike. I have a bad case. It is okay. I know. Okay, that's like practice. Okay, so now after those common modes of termination, we have what we call summary termination. It's a different one. Summary termination. Okay, one confusion. Okay, summary termination. Which law provides for summary termination? Yes? Section 60. Yes, let's read section 69. Summary termination. Okay, it says
Summary termination shall take place when an employer terminates the service of an employee without notice or with less notice than that to which the employee is entitled by any statutory provision or contractual term.
okay, where in our contract we say the notice shall be for 4 months. No perhaps means 2. That means you have summarily terminated March. But what happens? By the time an employer does that, always they have a way out. Now, I will pay. You saw what happened to Person Ronaldo. The only country that doesn't pay is Uganda. They terminated Mitchell's contract. Okay? Up to now, at Yavande. They want to see the money. Payment in lieu of contract here. Criminal case pending. People have issues. Okay, so once you see that the notice what that was given, it is summary termination, not dismissal. People have issues with summary termination and summary. Okay, then another type of termination is known as collective termination, section 81. Yes, summary termination, where the contract says you should be given a notice of this. So once you terminate without giving me a notice, or you give me a less notice, it amounts to summary termination. Yes, okay. Another one is collective termination, section 81. Okay. Now, that one is the easiest mode of termination. It happened in COVID. Okay, so let's read. So, for you to collectively terminate, section 81 has given you grounds based on to terminate more than 10 employees. So, collective termination is where you intend to terminate more than 10 employees at once. So, it has conditions for you to terminate under such circumstances. Let's go on.
Where an employer contemplates terminations of not less than 10 employees over a period of not more than 3 months for reasons of uneconomic.
So the first one should be economic problems. Company teyakola. Namwe namukola ki? Olwaki mukiraba omuntu omusajja tumusika mukendeereko. Okay, akalulu kakwata. Now let me give you an example. Salvador works on which radio station? Sunny. Never happened Sunny FM. They did what we call collective termination, but it was not lawful. But because they kept quiet. Okay, the guy terminated all the employees at once, and they hired Salvador the following day. They hired the station. bwe balekako bokka basoma amawulire. That's how Salvador came to that radio station. All morning programs were done by Salvador, one man army. Yes, because the employees were demanding. And remember during COVID, they were falling under essential workers. They traveled every day, okay? But what happened? The guy didn't pay. We all understand that it was economic problems. But what happened? He didn't explain to them. They just received terminating letters. Bonna ne bakeera ne bajja ate ne batagulawo ne bagenda ku sit down strike. Najja ng'alina ebisumuuzo ebyanga kati mulina amagulu tetuddamu nakuteesa. Enkeera n'aleeta abakozi abafe n'aleeta Salva. But it was unlawful. But nani eno ki? Ganda singa Bulaaya. We go on. Another ground, technological problems. Who has never taken his car to City Oil? How do they work? Ojja mechanic wakiseka n'omutwala ku City Oil wagwa tajja kola tasobola. Wali tewali kwesaba oil, you bring your car, just turn to the computer, they start changing where the bolt is, they fix it using the computer. Omwana we wakiseka ayagala n'aluma amagalo n'akiteeka wano n'atekawo spanner n'ajja. So once you change to what we call technological advancement, okay, and the employee doesn't adopt that change, kindly terminate. You saw what happened in COVID. People started operating online. So where employees failed to adopt to technological change, the law allows you to let them go peacefully. Okay. Then another reason is structure or infrastructure. What are the where the infrastructures are not sufficient to accommodate you. So under such circumstances, you terminate because of infrastructure reasons. Okay. So you terminate that. So that is but however, another condition, if all these employees belong to trade unions, you should first notify their trade union leader. Oh no, after infrastructure, another condition, if they belong to a trade union, you should first notify their trade union leader. Okay, you should notify their trade union leader. Okay. Okay. So now, if you terminate someone's contract in ways other than those, it becomes I want you. Hey, Jesus. What is something unlawful is not allowed under the law. Does the law allow termination? So it's called unfair. Do you have unlawful dismissal? Yes. Hey. Hello. Hola. So that means we are transiting from the types of termination to what you people call unlawful termination. If it is fair or unfair termination. After that, one way shall be something unlawful is not allowed under. Something unfair, where the grounds according which you've done something, it's not possible. Okay? This is section 71. Look at section 71. We don't have unlawful, we have unfair. You know why? You know why? The law allows. The law allows termination. Okay? The law allows termination. So let's read 71. Okay?
An employee who has been continuously employed by his or her employer for at least 13 weeks immediately before the date of termination shall have the right to complain that he or she has been unfairly terminated. Two?
Okay. So now,
Okay.
when you look at 71, it doesn't tell you what circumstances. Okay? What circumstances? Okay? Look at 73.
73 is criteria for unfair termination. Subsection 1, a termination shall be unfair for the purposes of this part, where A, the termination is for any of the reasons specified in section 75.
When you go to section 75, it gives you that if your contract is terminated on any of the following grounds, it is unfair. Mulimu taking leave, okay? Okay? Sickness, pregnancy, or anything related to pregnancy, okay? It becomes unfair. You get it? Okay? So you will read. Okay, let's look at 75 briefly. Yes? We said unfair termination. The reason why it's called unfair termination, the law allows termination. So terminating a contract is lawful, but the law has specified how you should terminate. The modes of termination we looked at. So if you terminate for any other reason other than the reasons under the law, it becomes unfair. So the law has told you under section 75 that if you are terminated on the following grounds, you have a right to go to court. Okay? Are we together? So let's look at 75 chapter. I don't know whether we shall be able to look at the workshop because they're soon coming here. Okay? 75. Okay?
Reasons for termination or discipline.
Yes, okay. Reasons for termination. It says the following shall not constitute fair reasons for dismissal or for imposition of a disciplinary penalty. A female employee's pregnancy or any reason connected to pregnancy. You see, you terminate my contract because of pregnancy. If not, that is a reason connected to pregnancy. Okay? Okay? Then B, the fact that an employee took or proposed to take any leave. Okay? You know, the girl child has suffered. Whatever girl child is supposed to okay, so that they leave. Okay, you see, but when you are taking your leave under the law, okay, then another one, an employee's membership in the proposed labor union. Okay, achimanyi bogenda mu labor union mugenda kuba enduulu ziri super. Saagala bagendayo. Agendayo nkugobye. Tulina bamaama abedda. Abo wali waliwo pate nsanga agenzeeyo. Olaba akapate okaaga. Yeah. African mothers will never see heaven. Okay? Then okay, so you see when you read 75, all the reasons under 75, once you are given facts and your client's contract was terminated on such grounds, it becomes unfair. You can go to court and complain. Okay, so any question on termination, okay, mark this. Termination is different from dismissal. So now let us go for dismissal. Okay, let's go for dismissal. Okay, so counsel, read for us dismissal. First things first, Dismissal is a right for only the employer. So employee want to dismiss your boss. And the boss is going. Okay, it's impossible. Okay, so let's see what is dismissal under the definition section. Okay.
Dismissal from employment means the discharge of an employee from employment.
First, okay, discharge of on the initiative of. So it is only the employer who has a reason to, but that being the caller for dismissal for reasons. Okay, proceed. Okay, I want you to listen to this word. Listen.
At the initiative of his or her employer.
Upon.
When the said employee has committed verifiable misconduct.
I want to underline the word verifiable. Okay, so that means dismissal is only and only available, only and only available where there is a verifiable misconduct. So how do we verify a misconduct? How do we verify a misconduct? That's about section 61 now. How do we verify? Verify means now we take kakaire wabya amabati karamu. You get it? So what does that mean? Verifying is giving a right affair. So you can't come to the conclusion to dismiss without verifying the misconduct. Section 61. Okay, hold on. 61. 66. 66. Okay, it says
notification and hearing before termination. Subsection 1. Notwithstanding any other provision of this part, an employer shall.
You hear that? Notwithstanding. What does that mean? The employer shall not come to the conclusion to dismiss without the following. Okay? So once you dismiss without following this criteria, what does it become?
Unfair.
Yes, we shall get there.
An employer shall, before reaching a decision to dismiss an employee, on the grounds of misconduct or poor performance, explain to the employee in a language the employee may be.
So, what does that mean? The procedure of verifying the misconduct is under section 66. So once they tell you that your employee has committed the misconduct, first verify it. To verify social present. That's why during the process of verification, okay, that's when we have suspension. We first suspend you. You remember what happened in the Land Commission? Okay, upon claims that Honorable Beecher had committed verifiable misconduct in government, it's not called this. It's not called suspension. It's called we first do the interdiction so that you don't interfere with our investigations. And when we do the interdiction, it's supposed to be paid. Your salary, half. You are still an employee. Remember where we started from. Continuous suspension doesn't say that you have been. So you see, when you read this, it's very connected like this. This is up. Okay? So now we shall read that section. Okay? Because we are trying to follow this time. So what happens if you don't follow that criteria? It is an offense under this act. Okay? Read subsection 4. Yes.
Irrespective of whether any dismissal, which is a summary dismissal, is justified, or whether the dismissal of the employee is fair, an employer who fails to comply with this section is liable to pay the employee a sum equivalent to 4 weeks.
You get it? Once you don't give this person a fair hearing under section 66, it is an offense. Under section 66, subsection 4. Okay? Okay? Mbola. Then, on top of that, we have another type of dismissal known as summary dismissal. Okay? Summary dismissal. The grounds of dismissal and summary dismissal are different. You get it? Okay? Which section provides for summary dismissal? Yes? Which section provides for summary dismissal? Okay? Let's go to section 69, subsection 2. Subsection 2. Section 69, subsection 2. You read it, class.
Subject to this section, no employer has the right to terminate a contract of service without notice or with less notice.
Theory, yes, theory. Okay.
An employer is entitled to dismiss summarily,
Uh-huh.
and the dismissal shall be termed justified.
Now, first stop there. Here, that dismissal shall be termed justified. You know why? Mu Luganda kibagamba nga kirabwa n'akola ki? N'ayonka. Nga you don't even want to look at it. Nga ulaje Hajat. Oyo mwana akyali wano. You get it? Proceed. Okay? Proceed to the section. Shall be termed justified.
Where the employee has violated or conduct indicated that he or she has fundamentally broken.
So, the ground for summary dismissal is fundamental breach of your duty in the contract. Okay? Other books term it as what we call a gross misconduct. So the question is, what about something gross? You do not need to verify. An example. I'm going to use this example. It's a bit hard, but for academic purposes. Okay? You ladies have maids. It's not so? You have maids. Okay? There is a certain madam. She was working in Centenary Bank. Okay? This madam had a maid. But the maid was a school dropout who was doing nursing. Okay? This madam, obwana bukaba nnyo. So kacyankola afunye empiso. Najja n'abala wano bw'ati. N'afumita wano kumusuwa. Okusensinga kati nga bakufumitako bw'ati omwana asingirawo. N'amala ng'ono nga tazzeemu kaaba. So mukyalo yalina 2 kids. Okay? So the first born, this maid used, because the maid came when the first born is around 1 year, and the second born was about 1 month and some few weeks. So these babies could cry at the same time. So she could cry and one. So she went out and bought a bicola. So she could pierce them on a daily basis. So one day, they had a neighbor who was also a part-time boss. So they had a maid also. The maid came and asked this madam, the baby cries and when the mother looks like this, the baby starts crying. I don't know what's wrong. I'm tired of this baby. But yours don't cry. What is the secret? Overworking. Then stupidly, she told her, so she showed her what she does. This baby is to keep quiet. Lucky enough, this maid had a kid in the village as well. She was a man. She cried. So then she went out as if she's going to buy something. She stood at the shop to wait for this one's boss to come back. She told her, Ma'am, okay, I'm going to disappear, but this is my number. In case of anything, please call me, but I will not come around there. Okay? But I want you to do me a favor. put a camera in your sitting room and the bedroom. Never start for 2 days. It is okay. It is okay. Then this madam was so curious. Why is this maid telling me? Okay. So she thought of it. She took like a week without doing it. But she had a concern. You can't tell me that this kid who the maid came when the firstborn is 1 year. Okay. The maid had spent around 1 full year. That means around 2. But the baby wasn't talking. Okay. And the baby was just trying to stand. That's where the baby stopped. But now the madam was like, what's wrong with my kids? They're not changing. So after this girl called her, Mama, what I take your camera? Then she was like, let me do it. Then after she did. So she connected them on her phone. You know, during the lunchtime, she was, let me check on this phone. On checking the phone, she saw a maid piercing her baby. So she came back home. She first kept home. She took her babies to the hospital to ascertain. You know what killed her? They told her the maid disconnected the sensory nerves. They told her this baby of 2 years will never exceed that stage. So the babies could not go in. Why? They could not sense any movement, any word. So that was the end of the. They could just grow the body, but the mind could not grow anymore. So that means they will never talk. They will never understand anything their entire life. Okay? Yes. Now, you are the employer of that maid. Okay? Will you do verification? You get it? You see? It is very nice. So that's what we call a gross misconduct. Why do you bring this maid? To take care of them. You get it? So she has been taking care of them. It is a fundamental breach of her duties. Okay? So as a result of that, also I'm got no, yeah, I don't know. Huh? Huh? So now the second way, okay? Okay? Okay, so now I want you to weigh. We have a verifiable misconduct and a gross, where an employee commits a gross misconduct. This is a conduct which is on the face of it. We don't need a fair hearing. We don't need a fair. They are very straight. So that's what we call a summary dismissal. And the law doesn't punish you for summary dismissal. Why? You have already committed an offense. Okay? So now, we distinguish dismissal, termination, summary termination, and summary dismissal. Okay? So now, after that, mark this, okay? Where the employee, okay, has the right to enjoy all those rights, okay? And the employer is in breach of any of his or her obligations, okay, is a ground for enforcement. So that means the last topic you have to look at enforcement of rights, okay? We've said all we've seen takes place during the existence of the contract of employment. So during that course, the employer is supposed to extremely adhere to what is in the contract of employment. Where the employer is in breach of any of the provisions of the act or the agreement, the employee has a right to enforce. So the question is, how do we enforce? What remedies are available in cases of breach? That's what we call enforcement. So that will take us to what we call institutions for enforcement of rights of employees. Under this, we shall look at the labor officer, we shall look at the tribunals and the justice court. Okay. So we shall look at institutions established for enforcement of employment rights. Under this, we shall look at the labor officer. Okay. We look at tribunals and then the industrial courts. So that means that's where the mood is coming from. Okay, so we need extra attention. We have to know under what circumstances the matter has got the labor officer, under what circumstances the matter goes to the tribunal, under what circumstances go to the industrial court, the jurisdictions and everything. Okay, so these guys are closing. I wanted us to go through the workshop. However, the circumstances have not allowed us. Okay, with all due respect, observe, allow us to bring this session to an end. May the good Lord bless you. Literally, I've covered basically workshop 1 and workshop 2. So we are only left with looking through the facts. Okay? Don't worry. Don't worry. Okay? Okay. Members, lastly, okay, let's listen. Okay, today we are celebrating, okay, one of our colleagues' birthday, and we are pleased to inform that today is Mr. Jeff Dandy's birthday. Okay. For that reason, right, this just together and we celebrate. Okay.
Why is the party cancelled? The party.
Yeah.
You're welcome. Oh, ikuze. Oli bulungi. Wali atuukirako ewaka.
Aida, the cleaner there.
Le response. And response Ingera bawa naik, ada kogi bawa tumbuhan di mulai kali. Jadi, dia orang agak ya cari dah kai. Apa kami ini sih dia? Karena tu gitu dia deh. Karena kita tuh. Mereka menggap.
Mereka ya sih menurut saya marah. Kalau dia nanti.
Ya.
Siza ai za wa ai oba wa
bw'ate agenda okutuuka ng'agenda okulaba ku siniya ono obuvuyo bonna bukeera ku magulu kakati n'olwekyo munaani okirina okusaba eddunga twawaddeomu the other side.
Mulaja tajja bagamba. I do not know. Korekera tuyinza kuba eriwo agenda gino nasana China waka. China boyfriend.
Stressing her, stressing really, yeah, it's not. Oh. Look at Chai. Look at Chai. Just like all you
New. Wagagamba gwo. Yajja microwave. sana talina waka. Nze nange neetya. Nange ate olwo batasobola kupuruvinga nti balina waka. Nabo bali awo ab'ekipuli bulala. Bali awo. Sirina googera nanyo gamu.